The Senate will please come to order. We'll begin today on this snowy afternoon with a moment of silence. Thank you. Are there any announcements this afternoon? Seeing none, hearing none, we have two referrals. House Bill H-433 being on the calendar for notice and affecting the revenues of the state under Rule 31 is referred to the Committee on Finance. House Bill H-171 being on the calendar for notice and affecting the expenditures of the state under Rule 31 is referred to the Committee on Appropriations. This brings us to the orders of the day. We have on the calendar for third reading, H-128. Third reading was ordered on April 21st, 2021. Are there any amendments before third reading? Please listen to the third reading of H-128.
H-128, an act relating to limiting criminal defenses based on victim identity.
The question now is, shall the bill pass in concurrence? Are you ready for the question? The senator from Windham is recognized.
Thank you, Madam President. As you know, I was on the podium yesterday, so I wasn't able to speak to this bill. And I want to just take a moment to talk about one particular issue related to the bill that is something that's been on my mind. The last couple of weeks, there have been two Black trans women killed, both of them in North Carolina. I believe the same men are responsible for both killings. And I mention it because Black trans women, they experience in many ways the most violence that is at the intersection of homophobia, sexism, and racism. So their names were Jada Peterson and Remy Fennell. And Peterson and Fennell are among 15 transgender people who have been killed so far this year. Of those 15 trans people, 9 of them were trans Black women. And I just did not want to have that go unsaid. So I will be voting strongly in support of this bill in honor of all of those who have faced violence of this kind, and most especially to honor the names of Jada Peterson and Remy Fennell. Thank you, Madam President.
Thank you, Senator. The question is, shall the bill pass in concurrence? Are you ready for the question? Please unmute. All those in favor, please signify by saying aye.
Aye. Aye.
Those opposed, nay. The ayes have it, and you've passed H-128 in concurrence. We have on the calendar for action H-199, read for the first time on March 10th, 2021. It was referred to the Committee on Judiciary, which report that has considered the bill and recommends that the bill to pass. Please listen to the second reading of H-199.
H-199, an act relating to validating legal instruments used in connection with the conveyance of real estate.
The senator from Windsor, Senator Nitka, is recognized for the report of the Committee on Judiciary.
Madam President, H-199 relates to powers of attorney used for real estate transactions. There are no amendments to the bill. H-199 amends Title 27 in two ways. It provides that a technical minor defect in a deed signed pursuant to a power of attorney does not make the deed invalid if it has been on file in the land records for 3 years without being challenged in court. Secondly, the bill fixes minor and non-fraudulent defects in powers of attorneys used for real estate transactions if they have been recorded in the land records for 3 years without being challenged in court. In the real estate context, a power of attorney is typically used to authorize a person to sign on behalf of the seller of a piece of property, a deed transferring the title. Another common power of attorney in the real estate context is to authorize an agent to sign a mortgage deed on behalf of the borrower who is entering into a mortgage loan transaction with a lender. In such cases, the seller's power of attorney needs to be filed in the land records along with the seller's deed in order for there to be clear title to the property, and the buyer's power of attorney needs to be filed in the land records along with the mortgage deed they gave to the bank in connection with financing their purchase. Prior to the COVID-19 emergency, powers of attorney were used in real estate closings, but more frequently the parties appeared in person and completed the paperwork. With COVID, the need to avoid in-person gatherings has caused the use of powers of attorney to mushroom. The pandemic has also caused a significant increase in the volume of real estate transactions, as many out-of-staters have sought to purchase property here. In addition, low interest rates and people's need to access the equity they have in their homes has caused a significant upturn in mortgage refinance transactions. All of this has resulted in a lot of disjointed closings involving powers of attorney and obtaining signatures from other people in different locations. When a person signs a deed transferring title to their property, they have to have their signature notarized. And the notary signs a statement on the deed called an acknowledgement clause. It says that the person signing the deed personally appeared before the notary and stated that they voluntarily and willingly signed the deed. If, however, the deed is signed by an agent under a power of attorney, the acknowledgement clause should say that the agent and not the principal personally appeared before the notary and voluntarily and willingly signed the deed on behalf of their principal. The problem arises as many deeds transferring property and mortgage deeds granting a mortgage interest in the property are pre-printed or from software, and the acknowledgement clause still says that the seller or the borrower personally appeared before the notary. However, because of the COVID emergency and the resulting increase in uses of powers of attorney, that is often not the case. As a result, the notary acknowledgement clauses in many deeds now say that the seller personally appeared and signed it, but in reality, it was the seller's agent who signed it under a power of attorney, and the buyer's title is now arguably defective. Unfortunately, that fact is not likely to be discovered until the person who bought the property goes to sell it years later. Finding the original seller so that he or she can execute a corrective deed can be difficult, or even impossible if the person has died. In that case, a time-consuming and expensive probate court process has to be pursued. H199 would deal with the situation by adding a new subdivision, expressly provide that if a deed has been on file in the land records for 3 years and there has not been a court challenge to it during that period, the deed is then valid even if the notary acknowledgement clause incorrectly recites that the party to the deed and not the party's agent personally appeared before the notary. H199 also takes the same approach to powers of attorney used in real estate transactions. Under new subsection E, a power of attorney that is witnessed and acknowledged before a notary is valid if it has been on file in the land records for at least 3 years without being challenged in court, notwithstanding that it contains a technical error. The new subsection E would also remedy non-fraudulent defects in powers of attorney that were remotely notarized pursuant to an emergency rule issued by the Secretary of State last year in response to the COVID emergency. Under the Secretary of State's rule, one can have a document notarized via video conferencing, in an application similar to Zoom. Basically, a notary can watch a person sign a document using a video conferencing application. However, because the remote notarization process is new, it is easy to overlook one of the many requirements in the Secretary of State's rule. H199 would validate remotely notarized powers of attorney if they have been on file in the land records for at least 3 years without being challenged in court. Importantly, subsection E would not validate a power of attorney obtained by fraud or forgery. It is also important to note that H199 also relates only to real estate transactions. Defects in powers of attorney given for other purposes, such as giving person control over an elderly relative's bank account, would not be validated under H199. In summary, H199 responds to the increased use of powers of attorney in real estate transactions resulting from the COVID emergency by providing that if a power of attorney has been in the land records for 3 years without any court challenge to its validity, then it is considered valid despite minor and non-fraudulent defects. Enacting this bill will prevent headaches and expenses in the future. Persons testifying on behalf of the bill were Teresa Corsones, Executive Director of the Vermont Bar Association, Chris Delia, President of the Vermont Bankers Association, Eric Fitzpatrick, of course, our Legislative Counsel, Andrew Michael, Vermont Attorneys Title Corporation, and Charles Storrow, Lobbyist, Vermont Bankers Association. The vote in committee was 5-0, and we ask for your support. Thank you, Madam President.
Thank you, Senator. The question is, shall the bill be read the third time? Are you ready for the question? Please unmute. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you've ordered third reading of H199. I will note for those listening today that there was a request to pass over S88, and without objection, we will. We will now move to H145. We have on the calendar for action, H145, read for the first time on March 23rd, 2021. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as set forth on pages 1,195 to 1,196 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of H145.
H145, an act relating to amending the standards for law enforcement use of force.
The senator from Caledonia, Senator Benning, is recognized for the report of the Committee on Judiciary.
Thank you, Madam President. May I speak to the underlying bill as well as the Senate's amendment?
You may.
Madam President, this bill amends the statutory statewide standard for law enforcement's use of force, including deadly force, that was established in our 2020 Act 165. The standards created in Act 165 are actually scheduled to take effect on July 1st of this year, but H145 amends those standards yet again, the associated unprofessional conduct statutes that prohibit certain law enforcement conduct. As a reminder, the standards provide that the use of force by law enforcement is lawful if it is objectively reasonable, necessary, and proportional, and that the use of deadly force is lawful if it is necessary in defense of human life. With respect to the underlying bill, Section 1 creates the standards for law enforcement use of force. Subsection A sets out definitions that apply throughout the statute. The primary change to the standards from the version passed last year is the change to the definition of prohibited restraint to chokehold. This change is made throughout the bill in various sections of law in Title 13 and Title 20. Subsection B sets out the standard for the lawful use of force in policing. It requires that any use of force by law enforcement to achieve any lawful law enforcement objective must be objectively reasonable, necessary, and proportionate. The objective reasonableness standard must be evaluated from the perspective of a reasonable officer in the same situation based on the totality of circumstances. And the analysis of objective reasonableness shall consider whether the officer failed to use reasonable and feasible alternatives to force. Subsection C sets out the policy for use of deadly force by law enforcement. It describes when the use of deadly force is appropriate. It provides that a law enforcement officer is justified in using deadly force upon another person only when the officer reasonably believes, based on the totality of circumstances, that such force is necessary to either defend against an imminent threat of death or serious bodily injury to the officer or to another person, or apprehend a fleeing person for any felony that threatened or resulted in death or serious bodily injury, if the officer reasonably believes that the person will cause death or serious bodily injury to another unless immediately apprehended. Subsection C2 describes the word necessary as when, in light of the particular circumstances, an objectively reasonable law enforcement officer would conclude there was no reasonable alternative that would prevent death or serious bodily injury to the officer or to another. The remaining subdivisions under subsection C provide that law enforcement shall cease the use of deadly force as soon as the subject is under their control or no longer poses an imminent threat. Law enforcement must use reasonable efforts to identify themselves when feasible before using force, prohibiting using deadly force against a person based on the risk that that person poses to themselves and no one else, and requiring law enforcement to intervene if they observe another officer using a prohibited restraint. Those restraints are defined in subsection A. In subdivision C6, it prohibits the use of a chokehold unless deadly force is necessary pursuant to the standards that have been set out. In section 2 of the underlying bill, law enforcement's use of chokeholds is amended. We are amending the crime that was created in the Act of 147 from 2020 that imposes criminal sanctions on law enforcement that used a chokehold that resulted in serious bodily injury or death. H145 changes prohibited restraint to chokehold in the new definition. Section 3 amends the section of law that passed in Act 165 prohibiting the Criminal Justice Council from training law enforcement on prohibited restraints. Again, it swaps out prohibited restraints and the associated definition for chokeholds. As far as the Senate reacting to all of that, Senate committee has basically swapped out the underlying Section 4 with the new one as described as follows. The section amends the justifiable homicide statute to modernize the language in subdivision 1 to make the intent clearer. And again, this is all starting on page 1195 of today's calendar. Section 2 would align the subdivision 3 with the new standards for law enforcement use of force. As with the other sections, this passed last year. The H145 changes two things about the justifiable homicide statute as it was passed last year. It adds the requirement that for a person to be justified in killing or wounding another, that they must reasonably fear imminent peril and believe that deadly force is necessary to repel the peril, and it will correct the cross-references in subsection 3 to account for the reordered subdivisions in law enforcement's use of force standards. Currently, subdivision 3 is likely unconstitutional, as it appears to provide protection for law enforcement that interferes with the constitutional protections against unreasonable search and seizure as provided for in the Fourth Amendment to the United States Constitution. Amended language in subdivision 3 provides that law enforcement are entitled to the defense of justifiable homicide if they kill or wound a person while using force that is in compliance with the standards now set out in section 1. In section 5, the amendment changes these sections in the unprofessional conduct chapter to replace prohibited restraint with chokehold, making those terms similar throughout our statutes. Section 7 deals with repeals because Act 165 made the standards for law enforcement use of force and justifiable homicide statute changes effective in the future, that is July 1, 2021. and H145 further amends both of those sections of law, this bill must also repeal the prospective amendments to ensure that H145 versions of the standards and justifiable homicide statute go into effect and not Act 165's versions. Section 7 repeals three things. The standards for law enforcement's use of force is passed by Act 165. The amendment to the justifiable homicide statute, passed also by Act 165. And finally, Act 165's effective dates for both of those sections. Your committee report changed the underlying bill's effective date from September 1st to October 1st. Madam President, the Senate Judiciary Committee heard from a number of witnesses. Sean Burke, the Chief of the South Burlington Police Department, John Campbell, the Executive Director of the State's Attorneys and Sheriffs, Susanna Davis, the Executive Director of Racial Equity and Chair of the Governor's Task Force on Racial Equality, the Agency of Administration. Bryn Harr was Legislative Counsel. Zachary Hazid, the Staff Attorney for Disability Rights of Vermont. Jennifer Morrison, the Executive Director of Policy Development for the Department of Public Safety. Dr. Eitan Nesradin Longo, who is the Chair of the Racial Disparities Advisory Panel. Falco Schilling, the Advocacy Director for the ACLU. Michael Sherling from the Department of Public Safety. Julio Thompson, the Director of Civil Rights Unit, Office of the Attorney General. And finally, Wilda White, the founder of MAD Freedom. Your committee vote, Madam Chair, was 5-0-0, and we would ask for this body's support. Thank you, Madam President.
Thank you, Senator. The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? The senator from Addison is recognized.
Thank you, Madam Chair, Chairperson. Madam President, sorry. May I inquire of the reporter of the bill?
You may.
Thank you, Madam President. I am, in looking at the language, I'm not familiar as much as you are, of course, with this, the criminal law statutes, and the term an objectively reasonable law enforcement officer is used throughout this section. And I'm wondering, is there a definition of that somewhere? Because it seems to me that reasonable is subjective, but then it uses the term objectively reasonable. So is there case law? Is there a definition? How do we know what that means?
Madam President, off the top of my head, I would say there is definition for a reasonable person. I don't know the answer to the question about what a reasonable officer might be defined as, so I'm going to have to get back to you on that for third reading, or at least one of our committee people may have to get back to tomorrow. I have another engagement, so I can't be on the floor, but I will make a note of that and try to get you an answer to that before third reading.
Okay, that would be great. I'm just wondering, is a objectively reasonable law enforcement officer different than an objectively reasonable person? Is there a difference there? I'm not sure. Just trying to parse out that sort of phrase. And then in looking on, I have a couple smaller questions. On looking on page 7 of the bill, H145 of the bill that came over as passed from the House, the language I don't think your committee changed this, but it uses the term guiltless. And I'm wondering, usually I hear the term not guilty, and is there a difference between guiltless and not guilty? Was it intentionally used here?
Madam President, could you refer me to the exact line you are looking at?
Yes, let me find it. It is section 4 under the justifiable homicide. It's the intro language. If a person kills or wounds another under any of the circumstances enumerated below, he or she shall be guiltless.
I would say that the term guiltless refers to something before a jury makes a decision. Not guilty would mean that a deliberation has had to take place and a jury has responded accordingly by finding someone not guilty of the charge. This terminology, as I read it, Madam President, is something before the fact that simply says you cannot bring a charge at all. It does not get to reach the jury.
Okay, that is helpful. And my final question is in that same section, I believe your committee actually, this is part of the amendment, but in that same section of when homicide is justifiable, paragraph 2, it includes, and this is not a change from current law, it includes burglary and robbery as among the things that would potentially instigate justifiable homicide. The others are all crimes against a person, like a person's body. And I'm wondering, what's the logic or your discussion about including burglary and robbery, which are more crimes against property?
We actually had quite a bit of conversation about this subject, Madam President, but the words that appear on the previous line that read forceful or violent apply to those terms as well. So while if someone, for instance, is breaking into your home, they are not necessarily threatening you, but they are doing so in a forceful or violent way to break into your home. We did not want to abandon the concept that someone might be able to use deadly force because they just don't know what might happen next. But I do understand we did have some considerable conversation about the extent to which someone should be able to use deadly force. And this was a fairly hot topic of conversation, but the intent is to use forceful and violent as modifiers of those two words.
Okay, that is helpful to understand that. Those are my questions. I look forward to the response from you or another committee member, Madam President, about the objectively reasonable law enforcement officer definition. Thank you for your assistance, and thank you, Madam President.
Madam President, if I may, if I can get the answer before we close out later on, I will come back during the chance to talk about announcements and give a response.
Thank you, Senator. The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? The senator from Windsor is recognized. Kindly unmute, Senator.
Sorry. May I inquire of the reporter?
You may.
Keeping on the discussion of reasonable, there have been episodes in which police violence has been justified based on what strike me and many people as subjective judgment, namely that the police officer was afraid, rather than that the police officer had objective reason to be afraid. And I would like to think that reasonable, as used here, would mean that there are identifiable, defensible reasons other than how the police officer felt. And I'm wondering if the reporter might address that. How are there objective, must there be objective, arguable reasons? Is that what we mean by reasonable?
Yes, I would definitely say, Madam President, I would definitely say that the committee's intent here is to step in that direction as far as we can without depriving completely an officer of the ability to use force when any reasonable person or reasonable law enforcement officer would recognize that there is some threat that is imperiling either the officer's life or someone else's. I will use the example of George Floyd's trial. The competing sides had different officers come in to explain whether they had an opinion on the reasonableness of what Derek Chauvin was actually doing. At the end of the day, it is up to a jury to decide whether or not that objective standard has been met. But a judge is vested with the authority to read into the jury instructions what they can and cannot consider. And this statute is going to be part and parcel of what will probably become standard jury instructions when those questions come up. It is literally impossible to try to cover everything one can possibly imagine. But our hope here is that these standards are setting guidelines that will make sense and clarify that the officer really does have to have some reasons that are acceptable when using deadly force, especially, and literally any use of force. We are taking our statute as it existed prior to last year's changes that essentially gave free rein to an officer to use whatever force they felt they wanted to do. We've come a long way from that with the act that we did last year, but we're coming another step in the right direction with this language here. I hope that answers your question.
So short version of verifying that I understand the reporter properly. What I'm hearing said is that I was afraid he was going to kill me, so I shot him, is not an adequate explanation.
I would argue that under the statute as it is now being changed, that would be correct.
Thank you, Madam President. I thank the reporter.
The senator from Orange is recognized.
Thank you, Madam President. This is language that may or may not be subjective, and I don't want to cover every possible situation that we might imagine. But in Vermont in the last couple decades, there have been several cases where police officers have taken the lives of individuals, and the public has questioned the wisdom, the circumstance, or justifications of those. Could the reporter tell us which of some of those high-profile events, whether it was a shooting in a church in Brattleboro or someone who was having mental health difficulties in his car in Corinth, or someone who was tased in Thetford, and there are probably a couple of others, all that were found to be justified, and there were no charges brought. There was no juries involved, and there were no charges brought. If this bill were to pass, which of those high-profile incidents that we're all familiar with would have how would this language bring a different result to the decision of whether or not to prosecute or hold a trial for those killings, those deaths?
Madam President, one of the difficulties is that each of the individual cases cited may not necessarily have risen to the level where all of us know all of the details about what each case had for fact pattern. And as I'm listening to the suggested examples, I myself am not familiar with the fact patterns that developed that made a decision on the part of the Attorney General to not bring a charge of some kind. What I will say is that when our committee first began to look at making changes to the justifiable homicide statute, we were rather alarmed at how lax it was with respect to an officer's ability to use force, including deadly force, and set out on a series of hearings in an attempt to make modifications to language. I don't know when these particular events you are speaking about, Madam President, took place, but if they took place prior to our changes last year, I will have to say that we are miles ahead of where we were back then, when the Attorney General would have fairly lax criteria to examine in deciding whether to bring a charge or not. The discretion of the officer was paramount in those considerations. We are seeking to move in the opposite direction and say officers should not only have to make very specific decisions, they should be trained in why they need to make those decisions. And I don't know whether or not our Act 165 from last year was in place at the time that the examples you've just recited happened. So it's impossible for me to answer other than to say we are trying desperately to understand the world around us and to put in a different culture, if you will, about how law enforcement uses force, especially when it comes to deadly force. And I will confess that I think it's still a work in progress. We learn new things every day, unfortunately, in the news. And this is a concept and a cultural change that may take a long while before we're all comfortable that we've reached the right result. But if I'm understanding the examples given, I would say that under the new language that we have now, there is a much different way for the Attorney General to look at considering bringing charges.
Thank you. And Madam President, if the likelihood is that there be several different results in some of those cases, then this is headed in the right direction. And with the understanding that it's a work in progress, I would endorse this step forward. Thank you, Madam President.
Thank you, Senator. The question is how the Senate proposed the House to amend the bill as recommended by the Committee on Judiciary. The senator from Bennington, Senator Sears, is recognized. Kindly unmute, Senator.
I'm trying.
Thank you.
Madam President, thank you. I wanted to respond to a couple of the questions regarding the bill. Last year, when we were doing S-119, we spent a lot of time talking about the constitutional basis for reasonableness, the objective reasonable standard. And it goes back to a U.S. Supreme Court decision in 1989 regarding Graham versus Connor. And in that case, the court ruled that ruled on how police officers should approach investigatory stops and the use of force during arrest. And the Graham test is 4 ways. It's objective or subjective test should be applied when determining whether a defendant was under duress at the time the act was committed, and that was the use of force reasonable under the Fourth Amendment to the United States Constitution, and on a suspect and how much force can be used. And the test is really the reasonableness, the proportionality to the acts and so forth. And actually, Graham came out of a case where a man ran into a store and allegedly was stealing things from the store, but he was actually a diabetic trying to get candy to ward off a diabetic reaction. The police followed him, stopped him, and that's what led to the actual Graham case. So the standard has been in place for a long time. The question really is how police departments have responded to the use of force and how we've improved that over the years. And I hope that helps a little bit some of the questions that have been asked.
Thank you. The senator from Caledonia is recognized.
Thank you, Madam President. I was able to get the following from Ledge Counsel in order to respond to the senator from Addison. Since the Graham decision, courts review law enforcement use of force with an objective reasonableness standard instead of using an analysis that considered the officer's subjective intent. The court articulated a few guideposts in setting out the standard for determining objective reasonableness, including careful attention to the fact and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. But the court also noted that reasonableness is difficult to characterize, and therefore the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene. It's important to note that the question of whether an officer behaved reasonably will turn on whether they complied with the use of force standards. So, Madam President, basically, there is a requirement on the part of officers, as opposed to the average individual, that they have to follow the standards that are now set out in this bill. A person on the street who is not a law enforcement officer certainly has the right to justifiable homicide, but the standards are slightly different. They don't have to abide by what a law enforcement officer must go in thinking through the process. I hope that answers the question, Madam President.
The senator from Addison is recognized.
Thank you, Madam President. And I thank my colleagues from Bennington and Caledonia for the answers to those questions. I do remain a little concerned if the standard has been in effect for a number of years, as the senator from Bennington said. I can't remember when he said the Graham decision was, but a number of years ago. And we've seen so few police officers charged or convicted of excessive use of force or even murder. So that does raise a little concern for me. However, if, as the senator from Caledonia said, this bill would increase that standard and strengthen that standard, then we're clearly going in the right direction. But I still remain concerned that the standard has not been applied very frequently to bring justice to people who've been victims of police violence. Thank you, Madam President.
The senator from Caledonia is recognized.
Madam President, I appreciate the comments from the senator from Addison, and I want to say that the standards are certainly being tightened up, which is what we are really motivated to try to do. And by clarifying what a law enforcement officer has for standards, it makes a drastic change from the lax standards that were in effect prior to our efforts last year, and even takes us a step further because we're changing what we did last year to tighten it up even further.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? Please, the senator from Chittenden is recognized.
Thank you, Madam President. May I interrogate the reporter of the bill?
You may.
Thank you. I am wondering when the committee last took testimony on Giglio files and the credibility of an officer to accurately represent the facts in an incident and their credibility in taking the stand in a trial.
Personally, Madam President, I do not recall when we last took any testimony, if we did at all, but I'll happily cede to any member of the committee, including the chair, if there's a difference of opinion, but that does not register in my mind as something we've been discussing in the recent past.
I do not see anyone who wishes to be recognized on that question at this time.
So before I yield on my interrogation, then, Madam President, I'd just like to say I appreciate that the committee is moving further along the path to taking in information around them about, what credibility gaps look like between the community and law enforcement. And we, have seen a lot of recent discussions in our state and around the country about an officer's representation of the facts in an incident, especially whether or not someone had a gun in their hand, whether or not they were handcuffed when thrown to the ground. So I'd really, just encourage the Senate Judiciary Committee to do due diligence on the credibility of a law enforcement officer, because that can hinge so much on whether or not they are considered to have used reasonable force in a situation.
Since I'm still being interrogated, Madam President, I want to say that I appreciate the comment. I will happily look to the case just decided this week to say that the culture that we are discussing appears to finally be making a dent in the judicial process. And my hope is that with this language being changed and tightened up the way we are trying, we are continuing that path to make sure the culture changes.
Thank you, Senator. The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? Please unmute. All those in favor, please signify by saying aye.
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 Those opposed, nay.
Nay.
The ayes appear to have it. The ayes do have it, and you've amended the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read the third time? Are you ready for the question? All those in favor, please signify by saying aye.
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 Those opposed, nay.
Nay.
The ayes appear to have it. The ayes do have it, and you've ordered third reading of H 145. There's been a request to pass over S 53, and without objection, we will do so. This then concludes the orders of the day. The senator from Windham is recognized.
Thank you, Madam President. Pending announcements, I move that the Senate stand in adjournment until Friday, April 23rd at 11:30.
The senator from Windham has moved that, subject to any announcements, the Senate do adjourn until Friday, April 23rd at 11:30. Are there any announcements? The senator from Washington is recognized.
Thank you, Madam President. Senate Finance will meet at 2 o'clock.
The senior senator from Caledonia is recognized.
Thank you, Madam President. Senate Appropriations will meet immediately after the fall of the gavel. Thank you.
Thank you. The senior senator from Chittenden is recognized.
Thank you, Madam President. A reminder that Health and Welfare will meet at 8:30 tomorrow morning rather than 9 o'clock. Thank you.
Thank you. The senator from Caledonia is recognized.
Thank you, Madam President. Senate institutions will meet immediately upon the fall of the gavel.
The senator from Windham is recognized.
Thank you, Madam President. Senate Government Operations will meet at 2.
The senator from Bennington is recognized.
Thank you, Madam President. Senate Education will meet 15 minutes after the fall of the gavel.
The senator from Addison is recognized.
Thank you, Madam President. Senate Natural Resources and Energy will begin work tomorrow at 9 a.m. Thank you.
Thank you. The senator from Windsor is recognized.
Thank you, Madam President. Today is Earth Day. We celebrate the birthday of Earth Day, which was 1970. We also celebrate some other extraordinary individuals through history's birthday. Immanuel Kant, J. Robert Oppenheimer, Charles Mingus, Jack Nicholson, and our own star of Senate Judiciary, Richard Sears. Happy birthday.
Happy birthday, Senator Sears.
Thank you.
Are there any additional announcements on this Earth Day? Hearing none, seeing none, the senator from Windham has moved that the Senate adjourn until Friday, April 23rd at 11:30. Are you ready for the question? All those in favor, please signify by saying aye.
Aye.
Aye. Aye.
Those opposed, nay. The ayes have it, and the Senate stands adjourned until Friday, April 23rd.